This writ petition is dismissed. However, the petition number 2 would be entitled to monetary compensation.
Pass over case from supplementary list item 12, the PS 1796 of 2023.
You have not filed your affidavit.
Your Lordship, I want some more time for filing of affidavit and producing the record also. I have already communicated them.
Whom have you communicated?
My Lord.
कि कौन है जो आपकी बात नहीं सुनता?
नहीं बात सुन रहे हैं थोड़ा इलेक्शन की वजह से थोड़ा वो लोग टाइम मांगने की सर.
You just tell me who is the person with whom you have communicated and how much time do you need to do the
Record they will produce by tomorrow. Tomorrow. So एक दिन के. Supplementary affidavit 1 week time. Counter already filed. On a specific query, your Lordship query, I will have to file supply the documents as directed.
So you produce the records?
Yes.
And then file your affidavit also.
Tomorrow.
How much time do you need to do?
1 week. 1 week will be
Affidavit also.
Affidavit also और क्या? जब record आ जाएगा.
Election का बात किए थे इसीलिए पूछ रहे हैं.
Lord.
Election का बात.
हाँ election में ही वो लोग बताते हैं.
That is why I want to know that how much time do you need? It is absolutely open date for you. You tell me when you.
Within 1 week. 1 week कर देने से हम लोग कर लेंगे. जो
Contradictory
direction है तो
नहीं है.
आपको करना ही है.
Is it not contradictory? That because of election they are not able to file.
नहीं आज नहीं हो पाया. ये मैं कह रहा हूँ. आज नहीं हो पाया.
Next week?
हाँ next week.
You see, it's a very small point.
Yes.
If we find it in the record, they don't have a case. But if we don't find it in the record, they have a full case. Simple.
Correct.
Then natural justice we need to see in a proceeding. Right?
Actually, I saw the record. उसमें था कि several opportunities were given. जो basic training है, he could not complete because of his medical unfitness.
Okay.
Now thereafter, notices were issued upon him, and he participated in the proceeding, and thereafter proper opportunity was given, and then order of dismissal was passed.
Okay.
At least 5 or 6 opportunities was given.
Because he had stated that the disciplinary authority has passed the order of punishment without any show cause to the petition.
That I will show.
That
But,
is not correct. It is
Lord,
correct or not correct?
my Lord, I cannot say right now because let them bring the record.
That's right. I will not record anything.
From counter affidavit, I could gather 1, 2, 3, 4, 5, 6, 7,
We
8.
need some
leads.
receiving. We need to see as to whether he has responded to that to show that he had received it.
Correct.
Suppose a person receives a show cause, right? You annex it in the counter affidavit. He may say that he is not aware of these show cause notices. But if he has responded to any one of them,
yes,
then his contention will be nullified by his response itself. Then he cannot say that he has not received any one of them.
I have seen the response also, but
We'll
I
see
don't
that.
want to comment.
No, you don't need to.
The points in my humble submission is this.
Sir, we have to give a date. You just tell me next week.
After next week, any date. Yes.
The points I want to make it clear for what the kind consideration. The finding of the inquiring officer is in favor of the petitioner.
We'll see that, sir. We'll see that.
And it differs, then you have to give.
We'll see that whether he has given reasons, whether he has issued any notice to you. Because not only reasons, he has to also give you a notice that he wants to differ with the inquiry, findings of the inquiry officer. Then he will call for your response to that, and then he has to pass it.
Minors, yes.
Right?
Yes, that
This
is
is
the
the
law of
procedure.
that. That is the law of that.
You have to ensure that this procedure
Yes,
is
yes.
followed in letter and spirit. Otherwise,
Yes.
the employee is prejudiced
Yes.
by
That-
virtue of the action of the respondents.
That is what the law laid down by that court. That has to be followed.
That's right. We'll see only that. At the counsel for the parties are present, kindly give your appearances. At the request of the counsel for the respondents, let this matter be posted on 13th of May.
Yes.
Okay?
Yes.
The required affidavit in terms of order dated 10th April 24 be filed latest by 10th of May.
Alright.
जब 10 तारीख को आप फाइल करेंगे, you can provide me a copy of the proceedings so that I'll just go through it, or you can just assist this court at the time of arguments.
And they will comply with the order and direction of the
They will
court.
file the affidavit.
Produce the proceedings file.
They will. They will.
Also, case item 13 from supplementary list. WPS 1983 of 123.
Yes, petitioner.
Well, we have filed the rejoinder.
What have you stated in the rejoinder?
Well, the petitioner and as well as petitioner's mother have never got any amounting for family pension of the mother of the petitioner. After the death of the father of the petitioner, which is on 3/3/1997, till the death of the mother of the petitioner, which is on 9/4/2018. Almost
Now
20
they are
years.
processing your claim.
My lord, they haven't stated that in their counter affidavit. That
No, but you have stated so in your rejoinder.
my lord, they
Place
have.
your rejoinder, please.
Which, my lord?
Place your rejoinder. Para number 6.
Yes, my lord. They have directed the petitioner to come to the district superintendent of education, Ranchi, on so and so date. But due to some medical purposes, petitioner was not able to go there by that time.
That's
And
right.
after that, petitioner has received a letter on 14/10/2023 asking for PPO number of the petitioner's deceased father. And the petitioner
You have given the required
have
information.
given the reply and provided the PPO number.
When did you provide it?
15/4/2024.
Okay, very recently. Very recently you have provided.
Yes.
You do the needful.
Yes.
WPS number 1983 of 23. The learned counsel for the parties are present. Rejoinder to the counter affidavit is filed during the court proceedings, which is taken on record. The learned counsel for the petitioner has submitted that the petitioner is entitled to receive family pension of her mother from the date of death. Family pension of mother from the date of death of his father, who expired on 3/3/1997, and the mother has also expired on 9/4/2018. The learned counsel submits that as per the rejoinder, the respondent, the district superintendent of education, Ranchi, called upon the petitioner, and the petitioner was asked to provide the details of PPO number of the deceased father of the petitioner. The
My lord,
needful.
this was the letter by the accountant general.
That's right. The deceased, pursuant to such communication received from the Office of Accountant General, the petitioner has done the needful on 15/4/2024 by a letter annexed with the rejoinder. Right? The learned counsel appearing on behalf of the respondents has submitted that now the PPO number of the deceased father of the petitioner having been provided, the needful will be done by the office of respondent number 6.
But the petitioner not served his copy of rejoinder to the. That will be done. I'll just pass on this.
That's right. In view of the amendments made in the rejoinder to the counter affidavit, this court finds that no useful purpose will be served by keeping the present writ petition pending, as the respondent number 6 has apparently taken steps and the PPO number of the father of the petitioner has been provided to respondent number 6. The needful be done by the respondent number 6 and appropriate steps be taken for release of admissible dues to the petitioner within a period of 6 months. 6 months, nahi lagi. Within a period of 3 months should be sufficient from the date of receipt of the copy of this order. The petitioner shall, you will forward the records of the writ petition. That's it. This question.
This case from daily list for finance to attempt to WPL 4378 of 2019, attempt 3.
Why 2 writ petitions?
Because one is by the management, one is by the workman who's agreed by non-grant of back wages. So his petition is confined to non-grant of back wages.
Who's for the, you're for the workman? Yes, argue please. Give some facts and then you can show the perversity.
I'll just give the.
Give a bird's eye view.
Just this the thinnest written notes if your worship has.
This one?
No, not it has covers. We have covered three compilations. Extra. Achha, we have anyways, what is it count?
It's there.
We have given out.
देखिए इसके नीचे होगा ये है इसको निकालिए
We have given out compilations in this binded.
गया okay by the time you have one copy
I do not have. I'll just pass on my copy. I will borrow it from Ajman.
yes yes please.
I have given first page is the dates. We have given very short dates which are on record. My learned friends list of dates is more. It's a longish one.
Okay.
The 7/3/2012 is the date of appointment minutes of the respondent as the relationship manager. He was on probation for 6 months. Now clause 19 minutes we have said is the relevant clause so far termination is concerned, and clause 16 also provides termination by giving 1 month's notice. 15/9/2012 minutes is probation period got completed. However, minutes in November 2012 it was extended. November 2012 minutes we reviewed and found that he's not able to complete his tasks. 27/11/2012 minutes by an email we informed him about the extension of the probation period by providing him one more opportunity to the workman to improve his performance. 19/7/2013 after the annual review held for the period April 12 to March 13, the performance of the respondent was found to be below expectation. As such, by later in 19/7/13 the respondent was informed about his underperformance and was directed to improve the performance. 19/12/2014 minutes we terminated his employment as per the appointment letter by giving 1 week's notice in terms of clause 16 as he was working on probation. A further check of Rs 54,193 was handed over to the respondent. 16/12/2022 minutes the presiding officer sets aside the termination. That's the included. These are the
What is the adverse remark?
adverse.
By expunging the
Oh, that is
Performance.
underperformance and all.
so So that is the reason for his discontinuation.
Discontinued. Now there are three issues which we have faced. One is that he was a relationship manager. Can he be termed to be a workman within the meaning of section 2S? Now your lordship will find, if I look on the award, it's very interesting to note that the learned judge says that the applicant, I am using the word applicant, has not pleaded nor proved that is a work. That's about it. But says that the management witness number 1 in paragraph 39 to 40, 43, 44 has answered that he could not appoint anyone or dismiss anyone. He did not have power to clear bill vouchers. He did not have the power to grant leave. He did not have power to
So basically the traits of a manager was not
there.
absent.
So these 5 things, since he cannot do, therefore his appointment or his job is clerical nature, and hence is a work. That's the simple answer by the learned judge. Numbers, one judgment we did not file it in the compilation, but we have. This is a recent judgment. May add notes to the compilation of this month from the Supreme Court. Para 25. Para 25.
The famous case in connection with the traits of a workman, what is that judgment? The entire activity of a workman is enlisted.
Bangalore Water Works.
No, there is another judgment. Anyways,
No, this verse absolutely is on the point. Therefore, para 25 your lordship sees. Page 9, paging at the top notes your lordship after the word SCC online, just below. Kindly may
25.
25. Or may I just take your lordship from 24, that will just for continuity.
That's
A bare perusal of the above makes it crystal clear that absence of power to appoint, dismiss or conduct disciplinary inquiries against other employees was not only the reason for the court to conclude in Ved Prakash Gupta that the appellant therein was a workman. At this juncture, we may note that although Ved Prakash Gupta was decided at three judge bench, in a later judgment by a 2-judge bench of this court in SK Mani was a Corona Sahar Company Limited, it was held that it should be borne in mind that an employee discharging managerial duties and functions may not, as a matter of course, be invested with the power of appointment and discharge of other employees. It is not unlikely that in a big setup, such power is not invested to a local manager, but such power is given to some superior officers also in the management cadre at divisional or regional level. The judgment in SK Mani Supra was innocent of Ved Prakash Gupta, but we do not find any inconsistency in the statement of law laid down by SK Mani given our reading of Ved Prakash Gupta as an unconsiderable. That being said, in our considered view, mere absence of power to appoint, dismiss or hold disciplinary inquiries against other employees would not be the sole criteria to determine such an issue. Holding otherwise would lead to incongruous consequences, and the same would illustratively mean that employees in high-ranking positions but without powers to appoint, dismiss or hold disciplinary inquiry would be included under the umbrella of workmen under Section 2S IDI. We cannot be oblivious of the impact of our decision. In this context, reference to a decision in Shiv Shakti Sugar Mills, so and so. So this is a so just because a person who is in an organization as big as Tata Asset Management, everyone can't have these powers. And ultimately, the Supreme Court, this is also a case of manager. It was said that no, he's not a workman. Now, the point is to another view. Your lordship will also have to take into factor who was under an obligation to prove the jurisdictional fact. But there is no doubt that whether a person is a workman or not is a jurisdictional fact. Your lordship have a jurisdictional fact, adjudicatory fact. Because if it is not an industrial dispute or if it is not a workman, then the labour court or the industrial tribunal will not have jurisdiction. So this is an issue of jurisdiction. That means I have given a judgment, Corona Limited, what is a jurisdictional fact, was an adjudicatory fact, it is in my compilation. So I am looking at it from the point of a jurisdictional fact. To bring it within the scope of judicial review under Article 227, whether your lordships can interfere and should interfere.
what was your written statement?
That is not a workman. From all my evidence in chief, I have annexed that is a managerial post, this is what he does. It was only in cross-examination they put questions. I'll take your lordship to the cross-examination straight away. In fact, the award itself is very clear. Award has
Let us
extracted.
see the finding.
Yes, fine. May I request your lordship, the award, there is a type copy in WPL 924, if your lordship takes up WPL 924. The award is.
Page number
Page number, kindly come to page number, type copy of page number 70.
70.
70, type copy of page number 70.
My God. This is how this award has been written.
I was told that the learned judge never got a stenographer during his entire career, so he used to write awards, handwritten and depositions also himself. Page 70, my lord, sir.
Page 70.
Now, your lordship will see para 7. After calling the pleadings of the respective parties, the following are the disputed issues which are settled in the case for answering a reference. Whether the first party, Ranveer Kumar Khan, is a workman within the meaning of IDA. This is the first issue. Second issue is not whether the ground of termination of service by management to the first party was an underperformance is fully proved and justified. And whether the order of termination of service passed is unjust, illegal, and so on. Now, the first issue, notes, is from paragraph 8. I would like to take up the first issue. Now, just I want your lordship to see page 73. Or not para 10, sorry, para 10, page 72, at the very outset of discussing. At the very outset of discussing the finding on this issue, I must state that in the entire pleading of the workman under challenge, there is no pleading as to what kind of nature of work he was doing. It is also a fact that even during entire examination chief, he has not said or given statement about the nature of the work that he was required to perform or was actually performing. Thus, it is crystal clear that neither in the pleading nor in the evidence there is any evidence or suggestive facts of the nature of the work that he performed. So, now this is his failure. I will show that the body known. Now, your lordship will come to the next page, paragraph. However, when the witness of the management, namely one Anu Verma, was examined as a witness of management, the workman had cross-examined the witness of Anu Verma, who has admitted the facts that what work the workman was not doing, what it was not doing, not doing. It is therefore the contention of the workman that oral evidence having come on the from the mouth of the management, if taken and considered in the legal perspective, should lead to only one possible legal corollary, that the workman as defined under IT section 2S. Furthermore, the workman has highlighted the statement evidence of management, whereas Anu Verma for suggesting that the court that if the evidence is read would lead to a possible inference that he was a workman. The relevant paragraph of our deposition is annual. In para 39, the witness has said, कामगार के साइन से किसी का पेमेंट नहीं होता था. No power to make things. Again in para 40, कामगार को किसी कर्मचारी के खिलाफ कोई अनुशासनात्मक कार्रवाई करने का अधिकार नहीं था. पैरा 41, कामगार को किसी कर्मचारी को छुट्टी अप्रूव करने का अधिकार नहीं था. अगेन 42, कामगार को किसी बिल या वाउचर को सैंक्शन करने का अधिकार नहीं था. 43, कामगार को किसी कर्मचारी के अप्रेजल करने का अधिकार नहीं था. Now, finally, the aforesaid evidence has come from the mouth of the management witness, and the contention of the workman is that the admitted evidence of management discloses that the workman was not at all discharging any managerial or supervisory work in the light of the evidence of the management, as noted in para 11 of the award.
How he has incorporated supervisory?
Yes.
In amongst all these
Yes,
findings, amongst all this cross-examination, does any one of it relate to supervision?
If at all, I can stretch it to not para 43 appraisal around. A supervisor will give appraisal or give at least.
Supervisor need not give
Give appraisal. In fact, your lordship is right. He will not even give anything. Yes, supervising the work will be supervised. No, not really, your lordship. I was stretching it also to bring it within. So this my lord says that since he does not do these 5 things, hence he is not a manager or supervisor. His job is clerical and hence a work. This is absolutely correct.
Can you read further?
Yes. It is further contended at para 13 by the workman that if the nature of the work as indicated in para 11 is excluded from the work of a person, it is only the clerical work that remains left, and therefore assuming that the workman was discharging the works as not indicated in para 11 of deposition of Verma would only mean that he was discharging clerical work, and the same would make the person as a workman as defined under section 2S of the Industrial Code. It is true that the workman has not pleaded about his nature of the work, nor has given in oral or documentary evidence to support the same. However, since from the mouth of the management evidence it has come on record as evidence capable of being used in the proceeding lawfully as an admission that he was not doing any managerial or even supervisory work. Therefore, as a legal secretary, I must say that the work which might have been done by the first party would fall as a clerical and would and indeed fortify the view that he was a workman as defined in the suits. This, according to me, is not only perverse but also is legally flawed. Now, there are two judgments I want your lordship to first see. If he had not appeared,
Yes, respondent. How do you respond to this? How do you defend this finding?
Lords, after appointment, the workman even mailed to the management for seeking KRA, key responsibility area. The same was not being provided.
No, that is not reflecting from the award. The findings in the award is based on the cross-examination of a
Admission.
particular witness. Now, let us see that if each one of them, let every statement made during cross-examination is correct, does it lead to a conclusion that he's a workman?
My lords, may I please come to the WS that is being filed by the management?
There are two things how to defend the award.
My lords.
One is that you defend the award from the award itself. You are trying to defend the award from the materials on record?
No, my submission is, my lords, at one side they are filing in their WS that he is doing managerial works, and subsequently the Anu Verma, witness number 1 with regard to the management, she herself during cross-examination she has accepted that he is not doing these things. And on
What
that
about
particular,
supervisory work?
sorry, my lords.
Supervisory work?
My lords, that supervisory word is being used because 2S includes managerial and supervisory.
Therefore,
My
by
lords.
default it has been used.
No,
Can
my,
it be used by
my lords,
default?
because the things that is being admitted by the witness.
So therefore, what all has been admitted by the witness,
My lords.
does it include supervisory work?
No, my lord, that doesn't.
Then matter ends.
My submission is, my lords, that because, please, my lords.
What was his pay?
50. My lord, to that extent, it is there. There is a judgment which does not say that if the payment is with regard to something, a handsome amount, that doesn't say that he is not a workman.
No, therefore, you see the definitions like
My lords.
idea.
Can I just come back in a couple of minutes? One more.
Come to the definition,
My
please.
lords. May I please, my lords? Workman means any person, including an apprentice, employed in an industry to do a manual, unskilled, skilled, technical, operational, clerical, or supervisory work for a hire or reward, whether the term of employment be expressed or implied, and for the purpose of any proceeding under this act in relation to the industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as consequence of that dispute, or whose dismissal, discharge, or retrenchments have led to that dispute, but does not include so and so.
Read Roman 4 also.
Violence. Who being employed in a supervisory capacity draw wages exceeding 10,000 per mention, or exercises either by nature of the duties attached to the office or by reason of the power vested in him.
So in
function-
case of supervisory capacity, the pay should not exceed 10,000 rupees.
My lords, my summation is
No, not
That-
the submission. You
yes,
just
that is there,
respond
that
to
is
this.
there, that is there. But actually, what she has admitted that these are the things that is not
Therefore,
there.
I asked you a specific question. Managerial and
Violence.
supervision are two distinct functions altogether. That is why two distinct words have been used under the Industrial Disputes Act. Right?
But the
Amongst the nature of work which has been illustrated in the cross-examination of the witness, none of them relates to supervision of work.
my lords,
And therefore, the salary of therefore, there is nothing to exclude supervisory function of the workman,
my lords.
right? Therefore, under such circumstances, how does the learned court comes to a finding that he was not doing supervisory work?
My lords, nowhere it is being provided by the management. What is the nature of work? He even asked
Are
that
you
he
not
had-
supposed to provide
My
for
lords.
yourself once an issue has been framed to this effect,
My lords.
that whether you are a workman or not,
My
it means that parties are joining issues on this.
That is there, my lords.
So you are not supposed to lead any evidence on that. You
Lords,
will not even say
evidence-
that what kind of work you were performing.
My lord, that is provided in the, my lords, may I please come to my counter affidavit, my lords.
Counter.
My lords.
No, we will see only the records.
My lords,
We
my
will not see your counter.
because my lords, there is nothing that he can provide by way of submission. My lords, his submission may, my lords, may kindly come to para 44 of the statement made by the workman, my lords. Para 44.
Where is that? Where will I find that?
In the convenience
Sorry,
compilation, page number 70 is the evidence of respondent.
My lords, in his statement,
Page 70 of on behalf of
the
petitioner
convenience
company.
compilation.
annexure 4 to the counter affidavit also, my lords.
Yes. Statement of Randhir Kumar.
My lord, that is the workman. My lords, in his statement, he has, to that extent, it is not being provided that what is the nature of the work that he is performing. The only thing that he relied upon during the cross-examination of Avnu Verma and in the statement also that is being made by her, with regard to that, nowhere it is being provided, that is nothing, not even a single piece of paper is on record which suggests that what is the nature of the work.
So
My lords,
who has to plead and
My
prove
lord,
the nature
that
of
is
work?
there, my lord. That is not on record yet. That I agree. But subsequently, it is accepted on the part that one side they are making in the WS that he is performing managerial work, and on the contrary, the witness in her cross-examination admitted that he is not doing such things, my lords. It is there in the WS, my lords. And
That-
even, my lords.
So you want to say that there is no stand of the respondent, of the management, that he was doing any supervisory work.
My lords, and subsequently it is being asked, my lords, and nowhere it is being replied by them also, and they have not bring anything on record that he is doing this kind of work which doesn't come on within the purview of the workman, my lords. He is not doing clerical job. He is doing.
You are shifting the onus to the management
No, that
straight
is-
straight
my lords-
away.
No, my lords.
Right.
May I?
This is how the matter is to be conducted.
No, my lords, my submission is that once that is being admitted and that
No.
has been observed in the award.
Where is the written statement of the management?
That is at
Written as statement, my lords, is
page number 6, Lordships, of the convenience compilation.
just a second, my lords.
So we have raised the preliminary objections over as the respondent being a workman, which paragraph 5.
Yes, yes. that is there.
There is one judgment of pharmaceutical companies, 94-5.
Lordships, medical representatives.
Yes.
Lordships.
There
We have
this
also-
issue has been decided.
Lordship, we have also annexed Lordship in the judgment.
These judgments have been considered.
Lordship, these are not considered Lordships. They have only considered Lordship one judgment of 1981, then trial labor code, which was before the amendment which was made to the under section 20BB of the retrenchment Lordship, definition of retrenchment under IDA.
My lords, in the writ filed by the management, page 36, last paragraph, my lords.
In the written statement also they are saying that the burden of proof is on you. Right?
My Unless they have made a statement, therefore the application is liable to be dismissed on the short ground. Further, the work profile of the applicant considered largely of official work of supervisory and managerial nature, which requires application. They have made this statement in their WS models, and subsequently it
Where
is
is
there.
which page number?
Page 36 of the writ application.
Page number, internal page number 2, Lordship, Lordship was reading paragraph 5.
You, it is internal page. You refer to the same compilation.
Sorry, Madam.
Yes, where it is? Internal page.
Internal page number 2, Lordship, paragraph 5, Lordship is placing the last 3 lines of paragraph.
Okay. Therefore,
Yes.
Yes, Madam.
so they have taken a stand that it was supervisory also. Managerial and supervisory are not one and the same thing.
But my lord, same contradicts the admission of the on part of the.
Where is the admission? Kindly show us the admission.
Though it is not in complete sense, my lord, but she accepts that these are not the things.
You see, it is. Have you done multiple choice questions ever? There are two ways of doing it.
Either
One is that you know the answer.
or
Other
you
is
are
by elimination. So this judgment has been passed by elimination.
No, my lords.
Then in that case, all the activities are required to be enlisted and then eliminated.
Lords, may I
Just
place?
4 activities have been enlisted and eliminated, and that makes you a workman.
Lords, to even their witness has not also proved that he is not doing the clerk.
That is not their onus. The onus is on you. When you are joining issues, the issue number 1 is whether you are a workman or not. Will you not at least assert that you are a workman?
Yes, my lord. In his statement, not even a single cheat. That is there. I agree. But yes, my lords, and what a workman can basically do.
How
my
long
lords.
have you been terminated?
Sorry, my lords.
How long have you been terminated?
You work, I guess, 2 years, near about 2 years, my lords.
2 years now.
No, in 13 itself. He was terminated in 14.
December
itself.
2014.
Joined services in 2012 and terminated in
Not
14.
covered by Industrial Disputes Act. Show me some material, something in the impugned award.
Lord, I accept to that extent that he has not proved that what is his nature of work. That is there. He has neither provided in his statement, neither even a single cheat. Because what he can do basically, my lords, if KRA is not being provided, then definitely the terms and conditions should be provided in the appointment letter that what is the nature of his work. It is silent. Nowhere it is being provided. Neither the KRA is being provided, even he is being
What is
asked
KRA?
key responsibility area, my lords.
Or key responsibility.
My lords. So he even made a correspondence to the management that I may be permitted that what is my nature of work. That is not being provided, my lords. And one fine day subsequently, and my lords, the ground on which he was being terminated is below expectation. My lords, I have annexed.
No, we are not concerned with the ground.
That is
Unless you get the get pass, you don't get anything.
my lords.
They are stuck with that issue only. Because they know that otherwise they don't have a case.
My lords,
Could
but
be.
yes.
We do not know.
Otherwise also, Lordship, we have a
We
case
also
manager
have a
because
case.
his probation was never confirmed, Lordship. His
That's
success was never confirmed. He was on probation.
No.
In that period, we have terminated his service.
My lords, he was on probation for initial 6 months. He was never being, the probation period was never been extended. And
You
he
say that it
continued.
was never extended?
No, yes, my lords. There is nothing on record which suggests that he has been, the probation
No,
period has been extended.
you have to show it from the findings. What is the finding with other issues?
Fine, may I please, my lords?
Para 16, Lordship, so far as the extension of probation period is concerned. It is
Para
the
16.
Page number 78 of the WPL 924.
Okay. Issue number B, para 15.
Para 16, Lordship.
Yes, para 16.
I have examined Exhibit W, which is the letter of appointment, which clearly indicate that he was initially appointed on the post of probation for 6 months, subject to extension at the discretion of the management. This is evident from clause 3 of Exhibit W, which appointment letter, which is the appointment letter. It is the admitted case of the management that the workman joined service of management on 15/3/2012. Means the period of initial probation of 6 months ended 15/9/2012. The further evidence of the management is that his initial probation of 6 months which ended on 59/2012, was further extended by giving email information to the workmen by management. This oral evidence is well set in paragraph 3 of the witness Anu Verma. This part of oral evidence has been thoroughly challenged by the workmen in the cross-examination. And in this context, paragraph 25, 26, 27, 28, 29, 30, and 31 of the witness Anu Verma can be referred to. However, the fact on record is that the said email of extending the probation from 59/2012 for further period or any extension of probation beyond has not been brought on record by the management. Since the email has been disputed, the burden of proving the email document of extension of probation was always upon the management as it had only made the assertion of positive fact of email. It is therefore safe to hold that the contention of management of extending the probation period beyond 59/2012 is not proved. It is also a fact that admitted on the record that termination of service of the workman is by letter dated at 19/12/2014, which is evident from Exhibit M by 2 and the statement of workman himself. It is therefore true to say
So
that
therefore, he has virtually passed an order on deemed confirmation.
deemed confirmation. That lordship we have annexed, given the judgment lordship on this point itself that deemed confirmation cannot be assumed by the court in absence of any confirmation letter which is issued by the employer. And when there is a provision to that effect in the appointment letter itself, that it
What
will
is
be-
his case? What was his case regarding probation? What was your case regarding probation?
My lord, after 6 months, he continued the work.
Mere by continuation, the probation does not get confirmed.
No, my lords.
It depends upon the terms and conditions of appointment.
My lords, my lords, may kindly see the.
I just want to know what was your stand before the learned court so far as your probation period is concerned.
His stand was that he was not being informed. He continued the work, and subsequently, one fine day, he was terminated. He was not been even the probation period has not been extended, and thereafter
Probation
he
period
continued.
was
the
not
work.
extended.
Not
That
extended.
finding has been recorded that
My
there
lord,
was
that
no
is- this is
extension of
the-
probation period.
Because they asserted that they made a mail to the witness W1 has been mailed to the workman that his probation period has further been extended, but that same document itself has not been brought on record and has not been proved by the documentary evidence.
That's all.
Lordship, in that regard, Lordship, there is judgment of the Supreme Court of India. 2019, we have also given the judgment.
Let me just see the judgments that you are relying upon and
My
go
lords,
to
last point, my lords. And my lords, the ground on which he was being terminated is the underperformance.
That's right.
And my lord, subsequently, I have annexed in my counter affidavit a letter for increment of salary. Increment of salary with regard to the CEO and the managing director was being provided to the workman during his service with us. And that is the ground they are taking that he is below expectation. That I don't find any relevancy with regard to the letter that is they have been provided that he is below expectation, and on the other side they are providing an increment to the salary.
Yes, let us see the judgments which you are relying upon.
Lordships, that we have also mentioned in the written submissions. Lordship may have the written submission, Lordships.
You have filed copies of the judgments.
Yes,
as of-
Lordship, we have also filed the copies of the judgment. List of judgments.
Yes. You cite one or two.
Lordships.
First on the point of.
First, on the point of the burden of proof, Lordships.
Yes.
That it is always on the workman to prove that he is a workman, so as definition of section 2S of ID Act is concerned.
Where is that?
Para 47, Lordships. That would be at page number 19 of the compilation.
Yes, burden of proof.
It is well settled principle of law that the person who set up the fee of existence of relationship of employer-employee, the burden would be upon him. In NC John versus Secretary so-and-so, the Kerala High Court held the burden of proof being on the workman to establish the employer-employee relationship, and adverse influence cannot be drawn against the employer. That if he were to produce books of account, they would have proved employer-employee relationship. In Sopandas Gupta was the first labor court of West Bengal. It has been held that where a person asserts that he was a workman of the company and it is denied by the company, it is for him to prove the fact. It is not for the company to prove that he was not an employee of the company but for some other person. The question whether the relationship between the petitioner or lordship, that is the law which is settled by the Supreme Court of India. That burden would be offered. And so far second and third judgment lordship is concerned, those are lordship relating to the salesman and medical representatives.
Second is medical representatives.
Second is my lords.
Second, third, and fourth.
Second, third, and fourth. Second is lordships on the point of probation lordship. That is on the point of probation. Para number would be lordships para 15. And even under general law, the services of the probationer can be terminated after making an overall assessment of his
See, it is
performance.
difficult to give a finding on probation. There is a finding of fact record.
But lordship, so far as probation is concerned, lordships, we would be relying on the judgment of the Supreme Court of India of 2019-17, page 157. Serial number 8, lordships, page 108.
Yes.
If I may please, lordship, the relevant paragraph. My lord, sir, para 41, page 122 of the compilation.
122.
My lord, sir.
Yes, para.
Para 41, lordships, 10th line from the top, lordships. The mere continuation of the services of the probationer beyond the period of probation does not lead to a deemed confirmation in service. It is only upon the issuance of an order of confirmation by the appointing authority that the probation is granted substantive appointment in the post. So far as lordships, serial number 6 and serial number
These are
Who is
in
concerned? Those are
special,
manipulation.
specific context of the rules,
lordships.
right? So,
But not general proposition has been held.
no, that is not the general proposition. It cannot be decided on general proposition. It has to be decided as per the service conditions and the rules.
But my lords, where a appointment letter is issued to the workman, it will be guided by that particular appointment letter itself.
That's right.
And it provides lords that it is the discretion of the employer to confirm or to assess the performance of the employee lordship. And
So
only
you go on
after-
doing it for indefinite period.
Because we have assessed the performance time and again, we have informed the workman about the performance as well. We have given him a opportunity to
You
improve
have
the
not given
performance.
him any extension beyond 2012.
14 lordship, we have given the extension till 14. We have
Where is that?
terminated.
No,
We have
there is no
terminated.
such finding.
Lordship, we have terminated the services on 19/12/2014. He was appointed in the month of March
No, where is
2012.
the last order of extension? The
That is
award,
not a-
the
that
award
is-
indicates that last extension was given only till 2012.
That is not on record, Lordship, although, but we have.
No, your submission will not, you have to argue your case from the records only. Please don't make any statement outside the record.
We are not making the statement that there was extension, but we are saying, my lord, that mere continuance of the services
That's
beyond the probation period, Lordship, that will not amount to deemed confirmation of
That's
service. That is our case.
Even if extension is not.
Even if extension.
What else? You read this 1994 5 Constitutional Bench Judgment,
Lordship.
737,
No, no.
page 48.
That is, Lordship's, the relevant would be page number 55 minutes. In the light of amended definition of workmen and wages and that of industry which has not been become operative, and we may now refer to the decision of this court on the subject. A 3-judge bench of this court on May and Baker India Limited versus Workmen had to deal directly with the question as to whether the medical representative of the company who was discharged from the service was a workman under the ID Act, and the order of reinstatement passed by the industrial tribunal was therefore valid. the court referred to the undisputed nature of duties of the employee and found that his main work was that of canvassing sales. Any clerical or manual work that he had to do was incidental to the main work and could not take more than a small fraction of the time for which he had to do the work. In the circumstances, the court held that the tribunal's conclusion that the employee was a workman under the ID Act was incorrect. The court also observed that the tribunal in that case seemed to have been led away by the fact that the employee had no supervisory duties and had to work under the direction of his superior officers. The court held that would not necessarily mean that the employee's duties were mainly manual or clerical. The court held that from what the tribunal itself had found, it was clear that the employee's duty was mainly neither clerical nor manual. Therefore, he was not a workman, and the court set aside the tribunal's direction for reinstating the employee. It is thus obvious from the decision that the contention of the on behalf of the workman before the industrial tribunal, as well as before this court, was that the employee was doing either manual or clerical work, and that not only he had no supervisory duties, but he was doing his work under the direction of his superiors, and therefore he was a workman within the meaning of the definition of the workman as it stood then. The dispute in question had arisen prior to 6/1956. The definition of workman at the relevant time included those persons who were employed to do any skilled or unskilled manual or clerical work. Hence, the relevant contention on behalf of the workman, which was negated by this court. An inference from this reason is also possible that if an employee's work was mainly manual or clerical, he would have, even as the definition stood then, been covered by it. The next decision is also of the same three-judge bench in Western India Match Company Limited versus Workman. The dispute there was whether the workman employed by the sales office of the company was entitled to production bonus as were those employed in the factory and factory office. The incidental question which arose in this case was whether the sales office was entirely independent of the factory and or was a department of the one and the same unit of production, and whether the inspector, salesmen or retail salesmen of the sales office were workmen within the meaning of the industrial.
That's right, we have seen it. Which is that judgment Berman's Shell.
So that has been discussed in paragraph 12. The Burma Shell Oil Storage and Distribution Company versus Burma Shell Management. Page 56.
That's right.
If I may please.
No, it's okay. Any other judgment you want to rely upon? You have relied upon serial number 1, serial number 8, serial number 4.
4 Lordship and so far
And
as
2 also.
2 also Lordship. And serial number 6 also Lordships on the point. That's where there is a specific time period provided in the contract, contract or the appointment letter Lordships, that would be governed by that particular Lordship's appointment letter, the stipulation made there in Lordships. And that cannot be beyond that period. And the employer will have a discretion to remove the employee even during the probation period. Lordship. That is the ratio. If I may please, Lordships, one paragraph of that judgment. Although we have quoted Lordships in the written notes of
Yes,
argument.
you have quoted the relevant portions.
Relevant portion, paragraph 4, Lordship, we have quoted.
Yes. Which judgments do you want to rely upon?
Minutes. First is minutes, I have provided the copy minutes. Mohan Lal minutes, 1981, 3 SCC 225. Well, in this judgment, minutes, the ratio that if the period of probation has expired and not extended, but the employee continued to work beyond the expiry of probation and then was terminated, the period of such appointment would be either temporary or permanent, but not on probation.
Which paragraph?
My lords, para 7 and 8 minutes. Lords, keynotes is also been provided.
You have given you notes?
Sorry, minutes.
They have given any notes?
Yes, minutes, not see that.
This one?
My lords.
This one?
Yes, minutes. One is list of dates and one is list of minutes.
Okay. All right.
Second is, may I please minutes?
Yes.
Ved Prakash Gupta versus Dalton Cable minutes. That is, para 12 is relevant minutes. A perusal of the evidence of Workman Witness 1 and Management Witness 1 regarding the nature of the duties performed by the appellant shows that the substantial part of the work of the appellant consisted of looking after the security of the factory and its property by deputing the watchman working under him to work at the factory gate or sending them to watch towers or around the factory or to accompany visitors to the factory and making entries in the visitors register as regarded the visitors and in concern registered as regard material entering or going out of the premises of the factory. It must be noted that MW1 has admitted in his evidence that there is nothing in writing to show what duties are to be carried out by the appellant. Placed in such a situation, the appellant might have been doing other items of such of work, such as signing identity cards of the workmen, issuing some small items of stores like torch cells, etc., to his subordinate watchman, which can be got from the stores, even under the signature of the watchman, and filling up application forms of other workmen and countersigning them, or recommending advances and loans, or for promotion of his subordinate. It must also be remembered that the evidence of both WW1 and MW1 shows that appellant could never appoint or dismiss any workman or any inquiry against any workman. In these circumstances, we hold that the substantial duty of the appellant was only that of the security inspector at the gate of the factory's premises, and that it was neither managerial nor supervisory in nature.
It is one thing to say that he was not performing these many functions.
I accept.
It is another thing to say that he was performing
these functions.
Is there any finding as to what work was he performing?
No, my lord. To that extent, what was the nature of the work that he was performing?
Negative list is there.
Yes, my lord.
But
Because
positive list is not there.
My
What
lord,
performance he
what
was doing?
performance he was doing, that is not there.
That is not
that I accept. But subsequently, it is their witness. They have provided. This is not being performed by him. But
They have not.
My
They
lords,
have.
even my lords, it is
You
the
have
owners.
cross-examined him,
Yes,
and therefore that has come on record.
my lords.
But there is nothing on record as to what work you were performing.
My lords, in this statement, neither, because my lord, that can be provided by the workman in his written during his chief.
He has not done it.
That is not there, my lords. And subsequently, no document is being exhibited because he tried to get the KRA key responsibility area. Neither any single point is being provided in the appointment letter. So that cannot be exhibited because of this reason.
The work allocated to a workman has to be proved only by documentary evidence.
No, my lords, it can be by way of oral statement.
Oral statement.
But
He has
yes.
not made any statement
He
as
has
to what
not
work he
made
was
that I accept,
performing.
my lords, and subsequently no.
So there is a negative list.
Sorry,
There is a negative list.
Yes, that is negative.
And that
but
is all.
Yes, my lord. And
But in this
subsequently,
particular judgment, there was a specific finding as to what work he was performing.
in this case, it was provided, but he subsequently it is if he is not doing this, that he must be doing this. That is the case. This is the reason I am relying on this point.
That's all. Anything else?
And my lords,
You have relied upon this judgment. Wait, Prakash Gupta. Other is Mohan Lal.
my lords, para 13 and 14.
Okay. Mohan Lal is para 13 and
No,
14.
my lords, Mohanlal is
Ved Prakash is para 13 and 14.
yes, my lord. Mohanlal is 7 and 8. Ved Prakash is para 12.
Para. But this Mohan Lal is para?
12, my lords.
Mohan Lal.
No. Ved Prakash. Mohanlal is para 7 and 8.
Para 7 and 8. Ved Prakash is para 12.
My lords.
These two are sufficient?
My lords, one more, my lords. Anand Regional Corporation, para 13 and 14.
Test to determine.
My lords.
Now let us see what is the test to determine.
The ingredients of the definition of a workman must be considered having regard of the following factors. Any person
Para
employed,
number?
para 13 and 14.
13.
Any person employed to do any skilled or unskilled work but does not include any such person employed in any industry for hired or reward. There must exist a relationship of employer and employee. The person inter alia excluded are those who are employed mainly in a managerial or administrative capacity.
Para 13 is the ingredients of a definition of workman.
Yes, my lords.
Para
And so
14 is
14
that-
for determining the question as to whether a person employed in an industry is a workman or not. Not only the nature of the work performed by him, but also the term of the appointment in the job performed are relevant considerations.
So I think this helps me.
Yes,
Okay, my lords.
this is the only thing you are relying upon.
My lords.
So what is is there any material to show the nature of work performed by you?
No, my lords. Nature of work performed, that has neither come on the part of the that I accept, neither come on the part of the workman by way of oral evidence. Neither there is any statement made by the management witness that what is the nature of the work. Neither it is
You
been
read
provided.
para 15 also of this judgment.
My lords. Supervisory contemplates direction and control. While determining the nature of the work performed by an employee, the essence of the matter should call for consideration. And undue importance need not be given for the designation of an employee or the name assigned to the class to which he belongs. What is needed to be asked is as to what are the primary duty he performs for the said purpose. It is necessary to prove that there were some persons working under him whose work is required to be supervised, being in charge of the section alone, and that too is being a small one and relating to quality control would not answer the test.
So in absence of nature of work being performed by the workman, how the court has come to a finding that no supervisory or no managerial I can understand for a moment, but how no supervisory work was being performed?
My lords, only on the ground that
On the face of the records, there is nothing on record to suggest as to what work the workman was performing.
yes, but on the other
It
side,
cannot be decided by elimination.
that is their words.
Now you come to the back wages.
My lords, back wages,
Were you employed anywhere?
no, Lord, that
Is
I
there
have
any evidence?
that I have provided in my WS is categorically sorry, my lords, in examination in chief that affidavit, evidence or not, my lords, he has categorically provided that he is unemployed. My lord, that is there only.
This is very interesting. My learned friends, please see my compilation, page 70.
Page?
Page 70 of this compilation. His case is,
Yes.
I, Randhir Kumar Khan, son of so and so, aged about 35, by faith, by occupation, I'm unemployed. So this is not even an affidavit. Your name does not form part of the affidavit also. Because if this
There
paragraph,
is no statement further.
no.
My lord, this is what is provided.
That is
and
what-
he has provided that, my lord.
I'm
He was
saying
conducting the matter in
But the
person.
name part does not form part of the affidavit because this is not verified. Paragraph so and so is verified.
But
He has provided
back
that.
wages has been denied to you.
Yes,
Yes, my lord,
because
that
there is
has
no
been-
evidence.
And my lord, that has been considered in the Paligundu Sarasway that my lords, it is even if he has not pleaded, then the burden lies upon the management to prove that he has been employed in this. That judgment is there, my lord, the Paligundu Sarasway.
It says that at least there should be a statement that he is not
Yes.
employed.
Yes, my lord.
Initial
that statement,
That trigger should be there.
my lord,
Where is that trigger?
My lord, that he has provided that in the, but that has not been verified. That I agree. It is in the initial part in the introduction.
So unemployed is his evidence.
Interesting case. There is a negative list and a positive
Yes.
list. That's all.
And as with regard to back wages, my lords, two judgments.
That even if it is not pleaded and proved, 50% is to be given. यही बोलना चाह रहे हैं?
Yes, my lords. That has been observed in the judgment. Para 38.1, 38.3 and 38.5.
And then back wages has been denied or given.
No, given. my lords.
Back wages has been given. So why have you filed the writ petition?
No, back wages is
For back wages, I have been denied in the. This is the reason I filed it.
So you are insisting that back wages should have been awarded. How much do you, according to you, should have been given to you?
As far as my client is concerned, I pay for 100%. my lords.
Without any pleading and proof.
And that pleading is not there. Rest, my lords.
The
to
pleading,
decide.
neither pleading nor proof. No evidence.
Evidence is not there, but he has provided in the affidavit itself, but that is not being verified. But my lords, he has that statement.
How much have you worked?
My lords,
How
he
many
joined
years?
in the near about 2 years.
He joined in 2012, March 2012, and was dismissed on December 2014. That is almost 2 years and 8 months.
I will just jot down your submissions and post for judgment on Monday. You take care of the submissions being recorded, right? First, your submissions.
Madam.
WPL number 924 of 2024 with WPL number 4378 of 2019. Both
Can I interrupt? Before there's an IA 4404 for an application is by us for seeking refund of the TDS which we have inadvertently paid to him.
yes, TDS has been paid to you.
3,82,000.
Are you agreeable for that?
I'll verify, my lords, and if that is the case, I'll ask him to get it.
But there is direction as
You,
to
last time also it was
we are
observed.
indicated.
But because reason being, I inquired, though he said, yeah, I'll just check and verify and according
This
to
will
Check
go
and
to his
verify.
account only.
It will go to your account.
His account only, his income tax, we will not keep it.
Yes, my lords, I'll ask him.
That must be refunded.
What is that IA number?
4404.
IA number 4404 has been filed by the management stating that pursuant to the order passed by this court, the entire amount relating to 17B of Industrial Disputes Act has been remitted to the workman, but due to inadvertence, the tax deducted at source has not been taken care of. Tax deduction at source has not been taken care of. The learned counsel submits that the interlocutory application has been filed for a direction upon the workman to refund the amount of
3,82,861.
382,861 so that the same can be credited
Yes.
in the account of the workman in the income tax department.
Against his
PAN number is
PAN
there.
number they think against his PAN.
He submits that the PAN number may be provided by the workman. To this, the counsel for the workman submits that if the entire amount has been credited, if it has been
It has,
credited,
it will go to banks, chala gaya.
But I have not inquired. Yeah, that has been transferred.
Transfer
to
ki.
he submits that the transfer of the entire amount is not in dispute. The quantity, the aforesaid amount will be remitted back to the management only with a further rider that the same amount should be credited in the account in the account of the
Respondent against his
of
PAN.
the workman in his income tax
Yes, ma'am.
as TDS.
As TDS. And a certificate to that effect will be issued.
And the certificate to that effect be also issued. Right? He also undertakes to provide the PAN number. After hearing the counsel for the parties on the interlocutory application, the tax deduction at source is a statutory deduction and the management is under an obligation to do the necessary deduction as per law. Accordingly, the workman is directed to remit the said amount of rupees वही जो amount है to the account of the petitioner. आप अपना नाम वो account detail दीजिए.
हाँ दे देंगे. Just a
हाँ, you provide it to the account of the management at the following, whose details are as follows, within a period of 1 week, 1 week, 1 week from today. Upon such, upon receipt of such amount, the management would immediately deposit the amount through the income tax portal to the credit of the workman and also issue appropriate TDS certificate to the workman. Unless it is shown in 2S,
Yes.
he will not get the credit.
No,
Show
we
in
will
sure that-
obviously we'll do that. It's all.
you should, the workman should also provide, you ask your client and give the PAN number also. On instructions, the counsel for the workman has given the PAN number of the workman, which is as under. Okay? Right. IA number such and such is accordingly disposed of. Now this matter?
Yes.
Matter.
My notes were.
These two writ petitions have been filed, arise out of the award passed by the learned presiding officer, Labour Court Jamshedpur, in industrial disputes case number 3 of 2015. Both the management and the workman is aggrieved by the impugned award. The workman has filed WPL number 924 of 2022, challenging the part of the award by which the back wages has been denied. And so far as the management is concerned, they have challenged the findings recorded by the learned Labour Court, particularly the finding with regard to particularly the finding that the
Can I suggest instead of workman, your lordship may use the word employee?
employee, particularly the finding that the employee has been declared to be a workman within the meaning of Section 2S of Industrial Disputes Act 1937. The foundational fact in connection with the present matter is not in dispute. The employee was appointed as relationship manager, work site solution, Jamshedpur, on probation for 6 months by letter dated 7/3/2012, and the clauses which has been relied upon by the management are clause 19 and 16, which are quoted as under. The probation period initially completed on 15/9/2012. However, upon review, the employee was not found suitable. The probation period was extended by email dated 27/11/2012 by providing one more opportunity to the employee to improve his performance. But his underperformance was reported during the period from April 2012 to March 2013, and ultimately, by order dated 19/12/2014, the employee was terminated, stating to be, in terms of the appointment letter, by giving 1 week's notice as per clause 16, as the employee was working on probation. Further, a check amount of rupees 54,193 was handed over to the employee towards full and final settlement, being salary for 1 month.
No.
May I please, Lords, on this ground, Lords? Lords, they have contended in that they will be handing over that amount of 54,000 in the court, but nothing is there on record which suggests that that amount has been paid.
We do not know.
No, that is there. It is there later, Lords.
No, is it, have you come against that also? Is there any finding to that effect?
No, there is no
Lord,
finding.
finding my submission
No,
to
please,
that.
we can't go, I am absolutely strict so far as these matters are concerned, we go only by the records.
No, but it is
We do
also
not-
not accepted that they have paid it.
We do not know.
But
We
my
just-
submission.
Because we have exhibited the check and the letter.
Check amount,
No, it is
They have
exhibited.
provided that it is being provided to him, but it is being said by the workman that an envelope was not having that check, and they agreed to that extent, and subsequently they issued a fresh check. But then they said that they will be handing over that in the court before the learned tribunal.
you see, we can't go on like this.
No, but my summation is what he is to that
You
extent.
should,
They should have filed an application. I could have
it
taken
can't be like
instruction.
this. And then
It is their letter, what they have provided.
we can't have it freestyle like this. The order of termination was under challenge before the learned labor. The learned council has referred to the award. The learned council for the management has referred to the award and has submitted that following issues were framed. Para 7. He submits that there was a serious dispute in connection with the fact as to whether the employee was a workman within the meaning of Industrial Disputes Act, and such stand was taken even in the written statement. He submits that it was specifically averred in the written statement that the employee was neither performing any managerial work and also supervisory work.
Yes.
The learned council submits that the learned court has clearly recorded that the employee has neither pleaded nor proved any material to show that he was a workman within the meaning of Industrial Disputes Act, but the cross-examination of one of the management witness has been taken into consideration to come to a conclusion that the employee was a workman. The learned council submits that certain questions were put to the management witness, and those questions being answered negative, the learned court recorded a finding that the management witness had admitted in evidence that the workman was not discharging any managerial or supervisory work, and therefore it has been held that the employee was a workman within the meaning of Section 2S of Industrial Disputes Act. The learned council submits that there is no material on record either from the side of the employee or from the side of the management as to the nature of work being performed by the employee. He submits that the law is well settled that a person who asserts a jurisdictional fact has to prove it by pleading and proof. Pleading and evidence. The learned council submits that merely because the employee was not performing certain work as per the cross-examination of the management witness, the same by itself is not sufficient to say that he was a workman within the meaning of Industrial Disputes Act. The learned council has further submitted that so far as the finding that the employee was not performing any supervisory work, the same is not borne out from the cross-examination of the witness as quoted in the impugned award. With regard to the probation period, the learned council submits that there is no concept of automatic confirmation of a probationer merely because the employee continued beyond the period of probation, the same could not have been taken, the employee could not have been taken to be confirmed, followed by consequential orders by the learned Labour Court. He submits that admittedly there was no positive order passed by the management confirming the employee who continued beyond the period of probation. The learned counsel, in support of the aforesaid submissions, the learned counsel has relied upon the judgments reported in
Serial number 9.
You just give me the paragraph numbers.
Paragraph 45 minutes of Durga by 2019-17 SSC.
He has relied upon the judgment reported in bracket 2004 bracket close 3 SCC 514 para 19
वो तो मैं दूसरा point
on the burden of proof.
अच्छा, burden.
I'm just enlisting
Oh,
the
okay,
judgment.
okay. Very good. All the
With
judgments
regard
are
to the burden of proof,
Okay.
uh, that is the only judgment on burden of
Yes.
proof. Number 2, bracket 1994, volume 2, SCC 323, para 15, to submit that there is no concept of automatic confirmation of a probationer.
Para 15.
Para 15,
Yes.
right? With regard to the meaning of workman under
Yes.
Industrial Disputes Act, he has referred to judgment reported in bracket 1992, bracket close 1, SCC 281. Give me the para number.
Para 19.
Bracket 1994, volume 5, SCC 737. Give us the para number.
Yes, I'll just write it down.
Bracket 2007, bracket close 8, SCC 559. He has further relied upon judgment reported in bracket 1997, 11 SCC 521 to submit that the employee is governed by the terms and conditions of the letter of appointment. On probation, accord judgment. Bracket 2019, 17 SCC 157 para number.
That is para number is probation.
You take this and write the
45.
para numbers.
I think I'll
Here.
do it. Para 45.
ये जरा दे दीजिए.
I'll do that.
हाँ, साइड में सारा para number. The learned counsel, so far as the other petition filed by the employee is concerned, the learned counsel for the management has submitted that there was neither any pleading, yes, neither any pleading nor any evidence that the employee was remained unemployed during the period of after termination of service. He has referred to the statement of the employee as contained in the convenience compilation, and he submit that the employee had simply stated in his name and address portion of the statement that he was unemployed, but no such statement has been made in his evidence. And accordingly, there is no statement of the employee that he remained unemployed, and therefore there is no question of grant of any back wages, much less full back wages to the employee. He submits that the aforesaid submission regarding back wages is without prejudice to his submission that the employee was not a workman at all within the meaning of Section 2S of Industrial Disputes Act. That's
In
all.
that regard, we have also annexed the judgment of Honorable Supreme Court of look at 2018 volume 18, page 299, para 18. Your Lordship's copy is we will give the paragraph. It is there in the notes also. In the notes we have
One more judgment?
on back pages. We have
Okay.
mentioned
The learned counsel has relied upon the judgment reported in bracket
2018 volume 18,
18, volume 18 SCC,
page 299,
page 299,
para 11 and 12.
para 11 and 12. The learned counsel has further relied upon recent judgment of the Honorable Supreme Court reported in bracket 2022, volume 3 SCC 6. There is one more here cited.
2024 Lordship's
Yes.
SEC online page.
Where is that? 2024 SCC. Where is 2024 SCC?
We have the 525.
Judgment passed by Honorable Supreme Court reported in 2024 SCC online 492. Para 25. That is all. The learned counsel appearing on behalf of the employee has submitted that there is no illegality and perversity in the impugned award, and considering the scope of writ jurisdiction against award, the findings recorded by the learned court with regard to the relationship of employer and employee does not call for any interference. He has also submitted that the learned court has considered the evidences on record and it is immaterial as to who has produced such evidence. The very fact that the management witness was cross-examined on the nature of work which was not being performed by the employee itself indicates that the employee being not performing such work which has come during cross-examination would fall within the meaning of definition of workman as defined under Industrial Disputes Act. So far as the finding with regard to probation is concerned, the learned counsel submits that admittedly the employee continued to work beyond the probation period and he was terminated only in the year 2014, and therefore the learned court has rightly come to a conclusion that the termination of services of the employee by treating him as probationer was not in accordance with law, and consequently the relief by treating the employee as a regular employee, as a workman and a regular employee has been granted by the learned court. He submits that the learned court has also taken into consideration that the performance of the employee could not be said to be not up to mark, as appropriate evidence was led before the court to come to such a conclusion. With regard to the payment of back wages, the learned counsel submits that it was for the management to prove that the employee was engaged elsewhere, and there being no evidence to that effect from the side of the management, the learned court ought to have awarded full back wages to the employee. For this, he has relied upon the judgment passed by the Honorable Supreme Court reported in
2013 volume 10,
bracket 2013 volume 10 SCC
324.
page number 324, para number
38.1 38.3 and 38.5.
Para 38.1, 38.3 and
38.5.
38.5. Dipali Gundu Service versus Kranti Junior Adhyapak Mahavidyalaya and another. The Learned Council has also relied upon the judgment passed in the case of Mohan Lal versus Management of Bharat Electronics Limited, reported in bracket 1981 bracket close 3 SCC 225 para 7 and 8. Then judgment reported in para 7 and 8. Yes. Judgment passed in the case of Ved Prakash Gupta, reported in SCC Thana
SCC 1984,
1984,
Volume 2, SCC 569.
1984, Volume 2, SCC
569.
569, para 12.
My lords.
Correct? And judgment reported in bracket 2006, volume 6, SCC 548, para number, para 13,
13
14
and
and
14.
15.
lords.
Judgment of Delhi High Court. Delhi High Court?
No, my lords, that to that extent. I'm-
That should be sufficient.
Yes, sir.
That's all?
Yes, my lords.
Arguments concluded. Post this case for judgment on equity. 8 जुलाई के बाद नेक्स्ट वीक कब होगा? 8 के बाद 15 जुलाई के ट्यूसडे 16 जुलाई for
There is an
judgment.
interim order of the Lordship has reserved the matter.
What interim order do you want?
Execution case Lordship is pending before the Government Labour Court.
Okay, the interim order is continued till the next date. ये जितने भी जजमेंट्स हैं ना, सारा पार्टी का नाम डाल के जो पैराग्राफ रेफर किए हैं, गोराई जी को बोलिएगा सब एक जगह कर देंगे, राइट? एंड देन ये सब अलग फोल्डर में डालें। आइए का जो ऑर्डर है that has to be uploaded. ज़्यादा नहीं लिखा, is it not? एक में मार्क किया, हाँ, दूसरा में मार्क नहीं किया ना? वापस
From supplementary list for panel disclosure, item 1, the rupees 2739 outbound quantity.
So you have to file a counter affidavit in this for the respondent statement. Because the counter is ready, unfortunately we could not serve the copy to the petitioner, so it has not been filed. So we'll
you
file.
serve it right now.
Yes.
Serve it.
One more counter has been filed from respondent number 5 and 6, which I have received today only.
Okay.
So I seek permission for 2 weeks to
Where
file
is the
joint
counter
report.
affidavit of respondent number 5 and 6?
5 and 6.
It is not on record. Where who is appearing for respondent number 5 and 6? Who is 5 and 6?
SC6 is mentioned here.
Milords, that only, we are only up there. Milords, we are for the respondent. State and municipal corporation, labor is also a party.
Yes.
We
So-
had direction, Milords, we will be filing.
You are filing on behalf of respondent number 5 and 6.
Yes, Milords, respondent state. One moment,
Learned counsel for the parties are present. A counter affidavit being filed by respondent number.
5 and 6 they have filed.
He is filing. Yes, which respondent are you filing counter affidavit right now?
Yes, Milords, parent department. Yes, Milords, 5 and 6.
Respondent number
5 and 6.
5 and 6 is filed during the course of hearing, which is taken on record. You give that please.
Yesterday also they have filed from the end of respondent number 3. 3, 5 and 6 they have filed, my lord.
Okay, the learned counsel for the petitioner submits that the counter, yesterday also one counter affidavit has been served upon him, but the same
Respondent number 3.
Respondent number 3 only we are filing. Milords.
on behalf of respondent number 3.
Respondent 3 only, Milords.
You are filing it on behalf of respondent
Respondent
number
number
3
3, parent department.
and respondent number 5 and 6.
No, Milords, that is not.
That has been filed.
Today I have received 5 minutes before.
That has not.
Where
been
is the
filed.
counsel?
I don't know. I received from some Ravi Kaketa.
5 and 6.
Please take down again. Counsel for the petitioner and counsel for the petitioner submits that some counter affidavits have been filed. You want to file a rejoinder and prays for time to file a rejoinder to
weeks,
the
ma'am.
counter
2
affidavits.
weeks.
He prays for 2 weeks time. Let the rejoinder be filed by 16th May.
Yes.
Pose this case on 10th of July under the hearing for admission. हाँ फाइनल डिस्पोजल. फाइनल डिस्पोजल में रख दें. Yes, counsel.
Final disposal.
It will come for final disposal only.
Item Q, WPS 3545 of 2023.
Yes, petitioner.
Mr. A.K. Sani will be arguing this matter. So he was present today at the court, today in the court, but due to some personal matter he has to do. So I pray for not today.
Pleadings are complete,
Rejoinder was to be filed on the last occasion.
but
time.
they have not filed it. By way of last indulgence, it's over. You pray for not today. We'll post it tomorrow. Counsel for the parties are present. MS, your name please.
Krishna Sagar.
MS Krishna Sagar submits that the arguing counsel, Mr. A.K. Sani, has left the court for some urgent reason. He prays that the matter be posted tomorrow. Post tomorrow. किसकी?
Supplementary item 18.
कहाँ? वासु 4 बजे किसका मैटर है? आपका लाइव.
My first prayer is for regularization, for the period 10th of August 2010 to 10th of September 2012. This is not the intervening period during which the petitioner did not work because he was dismissed. Let's say the second JPSC, let's say CBI, initially a business case was instituted for interrogation into the entire appointments period, and subsequently, let's say PIL was filed and the matter was handed over to the CBI for investigation. Now, still till date, the CBI is investigating the matter. In the meantime, 19 persons have been terminated, including this petitioner. All have been reinstated in 2012 and imposed the order that the order of termination was quashed, that is annexure notes 3. So now after that,
Annexure 3.
just annexure 3 at page 32.
You were also party in this? You were party in this litigation?
I forbid it is the petitioner
It is your case?
who challenged the order of termination,
Okay. Mahesh Kumar Mehta.
which has been finally
Mukesh Kumar.
Mukesh Kumar Babu, same petition.
That's it. Where is the order? Let's read that order.
Yes, please. Order page 32, IA number 1790.
Yes, I've seen that. You come to para 35 straight away.
Para 5.
Para 35. Base 35.
Page 35, yes, please. Note the concluding portion is, in view of the above, the impugned order dated 10th of August 2010 is quashed. This writ petition is allowed. However, it is made clear that this court has not gone into the merit of the allegations against the petitioner, and this order does not mean to prevent the respondents from proceeding against any such alleged charges by observing the principle of national justice and the procedure established.
You read para 12 also.
Correct. From the admitted facts appearing on record, it is clear that the preceding chain of events, as also the admission on the part of respondents in counter affidavit, led to a definite conclusion that the services of the petitioner has been terminated on the basis of inquiry of a serious charges of securing employment by malpractice, nepotism, favoritism, and misemployment. The said conclusion was arrived at by the respondents without informing the charges to the petitioner and without giving any opportunity of hearing and representations. The inquiry report, as admitted by the respondent,
That's right.
led to termination of the order.
What happened thereafter?
Thereafter, petitioner, this order has been set aside. Then, the next page is that the state government has taken a decision to reinstate the petitioner in the service. That is, annexure 4, page 36. There were 3 petitioners, all were in the police department on the post of deputy superintendent of police. And then, the petitioners joined on 11th of September 2002. So now the period between my termination and reinstatement, that has not yet been recognized. So therefore, my first prayer is
No fresh proceeding?
no fresh. Actually, what has thereafter no fresh proceeding. Then the matter went up to Supreme Court. So I will close that order also. They challenged this order in appeal, LPA. That LPA has few days back it has been dismissed also. Because the Honorable Supreme Court has said that all LPA shall be decided under the law prevailing under the service jurisprudence. So
When
for
is
the
that order of Supreme Court?
Supreme Court.
The party went to Supreme Court straight away from the writ order.
Lord's party went to page 38. Lord's LP order we could not enclose, Lord, but it has not yet been uploaded.
No, I fail to understand. The LPA was filed after the Supreme Court's order.
No, LPA was filed, Lords. All the LPA and the PIL which was pending, that was clubbed together. Then, Lords, some order which was passed in, Lords, the common order that these petitioners will not be allowed to work and they will not be petitioned. So, Lords, some SLP were filed in the Supreme Court.
So unless we have that order, how do we decide it? Now you say that in few days back some order has been passed.
In the LPA.
in
LP, yes,
We need to see the.
Yes, we
order
need
of
to see the
LPA,
order.
LP bloods, LP orders it is not uploaded. So bloods it can be
Taken up after.
because only if my lords may kindly see annexed.
And what happened in the criminal case?
Criminal case still bloods investigation is going.
Investigation is going on. Which is that case in which investigation is going on?
Bloods, that's a different story. Story is only this: they say that JPSC should provide us the copy so that we can make an inquiry. Honorable Supreme Court says that if the rule does not permit, how can we direct? Lord, here the things are being. Your spells may kindly see page 38.
This is WP 3594 of 2011.
Yes, that was the PIL number, and the final order passed by the Supreme Court at page 38. Annexure 6. ये number है, order नहीं है. Order नहीं है. Here, it starts from in this batch of appeals. The SL is to judgment dated 14/6/2012.
You produce a copy of the LPA.
LP
We can adjourn it for some time.
minus
LPA number?
LPA number 247 of 2011.
Decided on?
13th March 2024.
Learned counsel for the parties are present. The learned counsel for the petitioner submits that the order of termination of the petitioner was set aside by this court in WPS number 6262 of 2010 on 28/6/2011. However, an observation was made that the respondents could take steps in connection with the allegation by in compliance with the principles of natural justice. He submits that no fresh proceeding was initiated. Rather, the order passed by this court was challenged in LPA number 247 of 2011. Out of certain orders, interim orders passed in the LPA, the matter travelled up to Supreme Court. And after the disposal of the matter by the Supreme Court, the LPA has been recently decided on 13/3/2024. The counsel for the petitioner prays for some time to produce a copy of the order of LPA. Pose this case on Ninth of July.
Earlier date. Actually, the promotion for that, the promotion
See, I don't want to say that order has not been uploaded. It should not be recorded in an order sheet, right? And we do not know when the order will be uploaded. We have an intervening vacation also. We do not know whether if a party would go to Supreme Court.
minutes.
So we cannot anticipate many things.
All right.
From supplementary list for financial item 3, WPS 5306 of the month 23.
Yes, petitioner.
In compliance with regards order dated 20th of March 2024, they have filed their counter affidavit. The respondent JPSC notes. It's about re-evaluation of my question paper, lots, wherein they have annexed their rules. They say only retotaling is permissible, re-evaluation is not permissible. The Honorable Supreme Court notes on similar footings with us has said that even if there is no such rules, that is permissible if there is arbitrariness and unreasonableness in evaluation process. Therefore,
Which judgment are you relying upon?
Last.
Which paragraph is this?
Paragraph 32. The plea that there is absence of a specific provision enabling the Vice Chancellor to order re-evaluation of the answer scripts and therefore the judgment impugned should not be interfered with cannot be accepted.
Para number?
32 at page 607.
Yes. Can you read it?
The plea that there is absence of a specific provision enabling the Vice Chancellor to order re-evaluation of the answer scripts and therefore the judgment impugned should not be interfered with cannot be accepted. Re-evaluation of the answer scripts in the absence of a specific provision is perfectly legal and permissible. In such cases, what the court should consider is whether the decision of educational authority is arbitrary, unreasonable, malafide, and whether the decision contravenes any statutory or binding rules or ordinance, and in doing so, the court should show due regard to the opinion expressed by the authority. Why, my lords, I say there is arbitrariness in evaluation of my question paper? For 1 mark, my lords, I have been kicked out for 1 mark. Can we have annexure 15 at page 55? There were 2 papers, Millards. On paper 2, Millards, question paper is there and marks allotted to me.
Page 55, yes.
Millards. Here, Millards, may find question number 1. Here, Millards, there are 1, 2, 3, 4, 5 sub questions, Millards, having 2 marks each. They have evaluated it 6 only. Now, Millards, kindly have another similar questions. That is,
no, evaluated it at 6 means they have given you 6 marks.
6 marks in total 6 marks. जब सबका 2-2 अलग-अलग अलॉट किया हुआ है,
तो एक-एक नंबर में मिल सकता है.
हाँ, 0 भी मिल सकता है.
हाँ, तो एक में मिल सकता है. It is a subjective question.
Yes, Millards, 0 भी मिल सकता है.
It is not an objective question.
ये-
Yes
यही-
or no or नहीं है.
यही तो दिखाना चाह रहे हैं हुजूर. अब यही सेम चीज देखा जाए क्वेश्चन नंबर 6.
Yes.
Here, Millards, they have marked it differently. 2, 2 and 2.
So,
And
can't you
then-
get full marks?
Out
Can't you
of
get
10.
full marks in one question?
No. I say, Millards, my submission is, Millards, for question number 1, evaluation pattern is different. Question number 6, and similar question, Millards, question number.
No, I don't get it. What is the difference in the evaluation pattern?
Here, Millards, every sub question contains 2 marks each. They have cumulatively given me 6. For the similar questions where another sub questions are there, 3 questions, they are giving me different marks for each question. And for the next, Millards, every next question, Millards, which is in subcategories, Millards, they are giving me different marks for each question. Annexure 9 also, question number 9 also.
Which examination is this?
It's a limited departmental examination for deputy collector. Because class 3 employees are eligible after having the certain service career minutes. They can participate in this examination.
Same examination which was considered in the morning.
Minutes, this is the first examination. Minutes. Advertisement came in 2005. Examination took place 2013. They cancelled the examination. 2020 January they have taken re-examination, and January 23 they have published the result without publishing the cut-off marks. Once I have raised question, they published the cut-off marks. I have scored 133 marks. Last selected candidate in my category, that is general category, is 130.
134. And you have received how much?
133. And Millards, another examiners, the second exam, third exam, and fourth examiners, for 0.1% I have been kicked out. For 0.1%.
No, those are different examinations.
Series of this one is first one, second, third, and fourth.
In succession.
In succession.
Different examinations.
Different.
It has, those examination has got nothing to do with this.
No.
What will happen if you get 1 marks?
Lords, I will be in selection zone.
The selection is complete?
Complete. The candidates have already joined. The training is over.
Then
They are already posted.
your candidature can be considered now?
Lords, my specific plea is, Lords, there are still vacant positions.
No. You see, if there is there any panel prepared? No. Unless a panel is prepared, suppose the result is declared and 150 persons are declared successful, but they do not join, it will not go to the waiting list. It will go to the next recruitment.
Yes.
There is no wait list, there is no panel. In absence of wait list and panel, or when the candidates do not join, it does not go to the wait list or to the next person in the series.
Here my case is not. There are still vacancies. They say the state government will notify whether vacancies there are.
No. It
My
can't
case
go to.
is if I get even
You
one
see, if
marks,
you want to get selected, then you have to challenge the selection of somebody. It can't be like this.
then Millards grant me some time. I
No.
challenge the last selected
No.
candidate.
No.
I challenge in the representative capacity.
No.
Millards, they have to provide me the details. Millards.
They will do everything for you. What will you do as a council?
Millards, the last selected candidate name and
No.
they are
We
having.
do not.
Millards. I don't have. I can only get my marks from their website. Millards. And the last cut-off marks for the categories. Only.
And what is your relief? You are not challenging the appointment of anybody else.
No, Millards.
Then
Millards,
you are not challenging the appointment of any person. Your only consideration is your revaluation of paper.
Millards.
So, what is the result of that revaluation? We will not pass an order in futility. Where will it take you ultimately? Even if we get your paper re-examined or this re-evaluation, then what will happen?
Millards, I will come in the zone of consideration. Millards. 134 is cut-off marks of my category. I will come in the zone of consideration.
So what is the result of that? It will take you nowhere. Because there is no challenge to any of successful candidates.
Therefore, Millards, I am praying, Millards. Millards may grant me some time, Millards. Within a week, Millards, I will file. They will provide me details, Millards. I don't have the name and address of the last successful candidate. Millards.
What is your counter?
We have said, Your Lordship, that there is no rule so far the re-evaluation is considered. As per our rule, we can only go for retotaling. And what he is reasoning.
Have you done the retotaling?
Retotaling is correct. They have given 133 marks is there.
Have you done the retotaling?
That has also been not done. Millards.
Have you done retotaling? They never applied for it.
They never applied for it. For moreover, what else they have asked,
Kindly
my
have.
answers to be re-evaluated. Re-evaluated in the sense a subjective question paper.
You see,
was
the grievance that they have given cumulatively mark 6. So these are essentially in the realm of retotaling.
Retotaling.
But not in the realm of re-evaluation. Re-evaluation is virtually, they will evaluate your answer sheet once again, it will go to some other examiner. Retotaling is a mechanical process.
Millards.
That is it.
That would be
Kindly
Because
have.
that grievance is essentially in the realm of retotaling, not in the realm of re-evaluation.
Kindly have annexure 16, Millards. Once they have shown me my answer paper, Millards, they are immediately, just 2 days after I have written to them, Millards, these are discrepancy in evaluation of my
That is
answers.
not evaluation, this is retotaling.
Here, my lords, I have requested them for my lords, para 1,
What have you stated here?
लक्ष्य प्रथम रूप समाहर्ता सीमित प्रतियोगिता परीक्षा विज्ञापन संख्या 5/2005 के द्वितीय पत्र के विभिन्न प्रश्नों में जिसमें उप प्रश्न निहित है जिसका प्रश्न पत्र संख्या 7 का अथवा 7A B C D के निर्धारित पूर्णांक 2.5 के विरुद्ध मुझे 2-2-1-1-2 कुल 7 अंक दिया गया। इसी प्रकार प्रश्न संख्या 9 का भी मुझे 2-2-2-1-1 कुल 8 अंक दिया गया। लेकिन इसके विपरीत प्रश्न संख्या 1 का उप प्रश्न 1A, 1B, 1C, D, E के निर्धारित पूर्णांक 2-2-2-2 के विरुद्ध अलग अलग कितना अंक मुझे प्राप्त हुआ यह उत्तर पुस्तिका में अंकित नहीं रहा है, जबकि सभी प्रश्नों का संगत संहिता के साथ नियम संख्या के साथ सही जवाब दिया गया है जिसका अवलोकन किया जा सकता है। जब उप प्रश्नवार अंक दर्शाया ही नहीं गया तो कैसे कहा जा सकता है कि उप प्रश्न में 6 अंक हैं।
देखिए, WPS number 3306 of 2023. The learned counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the petitioner submits that, as per the counter affidavit filed by the respondent, there is no provision for re-evaluation. Rather, there is a provision for retotaling of marks. The learned counsel for the petitioner, at this learned counsel for the petitioner has relied upon judgment passed by the Honorable Supreme Court reported in bracket 2009, bracket close 1, SCC 599, para 13, para 32, to submit that the Honorable Supreme Court has held that re-evaluation of answer script in absence of specific provision is perfectly legal and permissible, and in such cases the court should consider whether the decision of the educational authority is arbitrary, unreasonable, malafide, and whether the decision contravenes any statutory or binding rule or ordinance, and in doing so the court should show due regard to the opinion expressed by the authority. In the light of the aforesaid judgment, the learned counsel has referred to Annexure 15 and has submitted that a marks of 6 out of 10 has been given en bloc, although it had 5 separate parts and each part was to be evaluated separately, but so no separate marks has been shown. He has tried to compare this question number 1 with other questions like question number 6, wherein the total marks was 10 and 2 marks each was provided in the different subtopic, and he got 6 out of 10. The learned counsel submits that had the respondents given breakup of marks with regard to each of the part of question number 1, then under such circumstances the petitioner could have secured 1 more marks and would have come within the zone of consideration. He submits that objection to that effect was raised by the petitioner by representation dated 28/6/2023, but having no response, he has filed the present petition. The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that there is no provision for revaluation and no such case has been made out by the petitioner calling for any direction for revaluation. He has submitted that the selection process is over and the persons have already joined and there is no private party in the present case, and otherwise also the petitioner is not entitled to any relief. To this, counsel for the petitioner has submitted that there are still vacant posts as many of the selected candidates have not joined. However, it is not in dispute that there is no panel or a wait list in connection with the selection process. After hearing the learned counsel for the parties and considering the fact that it is admitted position on record that there is no provision for re-evaluation and what is provided is only retotaling. It appears from the records, from the arguments advanced on behalf of the petitioner that the petitioner is primarily aggrieved by grant of 6 out of 10 marks en bloc with regard to with regard to question 1, which had whereby definition of five items under the Jharkhand Service Code was required to be given by the candidate. From the perusal of question number 6,
6, 7 and 9 also.
from the perusal of question number 6, it appears that the total marks was 10 marks and there was a choice, and in the choice question there were 3 sub-items. 3 sub-items: transfer allowance, transfer grant and daily allowance for continuous. And separate marks was allotted to each of the sub-item against the total marks of 10. This court is of the considered view that no such case of arbitrariness or unreasonableness or malafide has been made out by the petitioner in the present case, calling for an interference in the matter of interference and asking the respondents to re-evaluate the question paper, the answer sheet of the petitioner. This court is further not inclined to grant such relief to the petitioner as the selection process is over and no private person has been made respondent in the present case. This court is also of the considered view that in absence of any wait list or panel, the vacancy the post which remained vacant on account of non-joining of the successful candidate, the case of the petitioner cannot be considered against such vacancies.
deeply out.
This petition is accordingly dismissed. आपका कुछ रह गया?
पार्ट है
कौन सा?
39, 40 and 40.
39
39, 40 and 40. Orders.
orders में है.
Lordship, next date दे दिया है 94 serial number है.
Date तो मिल ही
Tuesdays
जाएगा.
पहले, Tuesdays पहले.
हाँ?
Tuesdays पहले
कुछ
because
खास बात है?
council जा रही है marriage attend करने के लिए.
उनके खुद की मैरिज है?
नहीं पता नहीं.
तो उनके मैरिज के बाद रख देते हैं. पिटिशनर को अर्जेंसी हो सकता है.
Petitioner में नहीं.
आप जा रहे हैं शादी में?
नहीं. वो council जो Union of India की.
What is the urgency in the case?
Re-medical करवाओ.
Sorry?
Re-medical of the candidate.
और pleadings complete है? काउंटर आ गया?
Yeah.
क्या ग्राउंड पर आप री एग्जामिनेशन चाहते हैं?
Because most of I have filed I have made representation regarding the re-medical examination, and the board respondent authority has rejected my representation. But other candidate has got the opportunity with the order of Honorable High Court.
यहाँ पे हुआ ऑर्डर? In the same selection process?
Yeah.
आपने अपील फाइल किया? Did you file appeal?
Yeah.
You have filed appeal against the medical examination?
Yeah.
That appeal was rejected?
No.
In the rejection order only it is mentioned that you file an appeal within 24 hours or 48
I
hours.
have not filed appeal, madam. I have made representation to the respondent authority, and that was rejected. After the rejection of that, I have made a petition regarding it.
Where is the other side? When do you want?
Before Tuesday, madam.
Next Tuesday? Wednesday को रख दीजिए supplementary list.
She will not be present.
She will not be present.
That is
She will be there in the next week.
Yeah.
Next Tuesday. Supplementary list. You prepare your list of dates. If you won't come with the list of dates and the judgments, then I will adjourn it for another month.
No, Lordship, I will send you.
क्या नाम है आपका?
Amin.
आपको पहली बार देखा? नए ज्वाइन किए?
1 year.
1 year. कौन सा पार्ट है? सुबह नहीं बोले? सुबह सोचे कि टेकअप हो जाएगा? नहीं, ऐसा नहीं है ना. कभी नहीं भी टेकअप होता है. क्या मैटर है?
Promotion का pleading counter law honorable court has directed to file specific counter regarding the fact.
Regarding
they have
which
already
Regarding which fact?
the juniors to the petitioner has promoted.
They have been promoted.
Yes, sir. So
They have filed a counter affidavit
Yes,
to that
sir.
effect.
Yes, sir.
But
they are not indicating that the notional promotion may be given to the petitioner. And Lordship also directed.
They are teachers.
Yes.
Juniors were granted promotion when? After your retirement or before your retirement?
Before.
You're before your retirement. You know your date of retirement?
Yeah, yes, sir.
It is mentioned in the writ petition.
Yes.
They have disclosed the date of
Yes,
promotion
yes.
also.
Yes.
कल रखो.
Your Lordship, item number 9, Lordship ने early receipt कर दिया.
9 में क्या है? क्या मैटर है मैडम?
Appointment matter है Lordship, और ये काउंटर के लिए डायरेक्शन दिया गया था 3, 4 and 5 को.
आ गया काउंटर?
No, Lordship फिक्स हुआ था 24/4/24 को तब तक वो फाइल कर दे, लेकिन
नहीं
वो
किया।
फाइल नहीं किया Lordship.
अच्छा, कल
Order
देखते हैं.
comply लेके.
इसको कल देखते हैं. कल रखते हैं? कल आप आ जाइए. ठीक है? We'll ask them to file a counter affidavit tomorrow. They are not here. किसको डायरेक्शन हम देंगे?
Lordship, respondent number 3, 4 and 5.
Are you there in this matter, madam? 9.
Serial number 9.
You have not filed your counter affidavit. Why? It's an appointment matter. The petitioner is crying. Yes.
Commanding judges.
How much time do you need?
Finish it 2 weeks. More time.
Counsel for the parties are present. Counsel for the respondents pray for and is granted time till 13th of May by way of last indulgence to file the counter affidavit in terms of the last order. Post this case on 14th May in supplementary list. ठीक है मैडम? Done?